Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in both Virginia and Texas, and of course, also licensed to practice before the U.S. Supreme Court. And today brings us to the U.S. Supreme Court, where we are trying to deal with the issue of students who have special needs. We have a public school system in the United States. Everyone is entitled to go to public school, and the public schools have to accommodate everybody, and not everyone is necessarily in the same position. Some people have disabilities, for example. These can be mental problems, they can be physical problems, they can be all kinds of problems. And basically, the government says, well, if you're going to have a public school system for everyone, you need to actually teach everyone and you need to accommodate everyone. This seems pretty reasonable, right? You could not have that system, but if you're going to, you got to treat everyone. Fair enough. So the United States Supreme Court was dealing with this issue recently with an individual who had problems with hearing. They're deaf. And the school was accommodating them, except, not so much. They weren't really accommodating them. They were pretending to accommodate them, but not really. And the parents were none the wiser because the school was lying to them for years. And they only found out about it as their child was getting ready to graduate. So the US Supreme Court is dealing with this issue about this student who was basically, the school was gaslighting the parents for years and years and years and years, and then trying to deal with the issues that come from that issue. So we're going to read this decision that just came down on Tuesday from the US Supreme Court. This is the case of Perez versus Sturgis Public Schools. And we're going to read the entire opinion and discuss. The Individuals with Disabilities Education Act, as amended in the U.S. Code, seeks to ensure children with disabilities receive free and appropriate public education. Towards that end, the law sets forth a number of administrative procedures for children their parents, teachers, and school districts follows when disputes arise. The question we face in this case concerns the extent to which children with disabilities must exhaust administrative procedures under the relevant law before seeking relief under other federal anti-discrimination statutes such as the American with Disability Act. Okay, so we've got this federal law called the IDEA law that gives children who are in special needs a process to go through in terms of getting them the help they need. So the school's like, we'll do this. And the parents are like, we'll do this. And if they agree, then fine. If not, then there's a process to go through to get them the results that are hopefully the right result, a due process result. Okay, so Congress wrote this law, IDEA. But Congress, of course, wrote other laws, such as the Americans with Disability Act. So one of the questions we might want to know is, does a student have to exhaust all their remedies under this IDEA law before they can invoke other laws? Does this law supersede, or is it primary in some sense over other laws? Or can a student seek relief under multiple different things? So that's one of the things we're trying to figure out. Do they have to exhaust everything under IDEA, or can they find relief elsewhere, such as the Americans with Disabilities Act? Okay. For the facts, from ages 9 through 20, Miguel Luna Perez attended schools in Michigan's Sturgis Public School District. Because Mr. Perez is deaf, Sturgis provided him with aids to translate classroom instruction into sign language. For years, Mr. Perez and his parents alleged Sturgis assigned aides who were either unqualified, including one who attempted to teach herself sign language, or who were absent from the classroom for hours on end. So not so much with the help. We were saying we were giving you help, but no. Along the way, Sturgis allegedly misrepresented Mr. Perez's educational progress, awarding him inflated grades and advancing him from grade to grade regardless of progress. Based on the school district's misrepresentation, Mr. Perez and his parents say they believed he was on track to graduate from high school, but then months before graduation, not so much. So this kid was in public schools until the age of 20. Most states, incidentally, allow you to remain in public school up to the age of 21 in case you're held back or something like that. So, of course, most students graduate at 18, but if you're held back, you might be older than that. And most states, 21 is the upper limit on that, as I understand it. So he was 20. He was 20, so apparently had some delays in there somewhere. But on the whole, everyone thought everything was fine. The school was advancing him and he was getting good grades, and the parents thought that he had the aides and teachers that he needed. But no, not really. They weren't actually there. And when they were there, they weren't qualified. And then a couple months before graduation, not so much with graduation with you. Yeah, that's not so great. In response to these developments, Mr. Perez and his family filed a complaint with the Michigan Department of Education. They alleged that Sturgis had failed its duties under the IDEA law and other laws. Shortly before an administrative hearing, the parties reached a settlement. Under the terms, Sturgis has promised to provide Mr. Perez all forward-looking equitable relief he sought, including additional schooling at the Michigan School for the Deaf. After settling this administrative complaint, Mr. Perez filed a lawsuit in federal district court under the Americans with Disability Act, seeking backward relief in form of compensation. So we're using the IDEA law to get forward-looking relief, different education, teach me, but we also want to get relief backwards under the Americans with Disability Act. Because, you've taken years away from me that I should have had, and now those years are taken away, so maybe I should have some compensation. That complaint drew a motion to dismiss from Sturgis. The school district argued that the provision of IDEA barred Perez from bringing an ADA claim without first exhausting all the IDEA administrative dispute resolution procedures. So the idea is that the IDEA law itself is some sort of superseding law or primary law, and you must exhaust that before looking somewhere else. Ultimately, the district court agreed with Sturgis and dismissed the lawsuit. Bound by circuit precedent, the Sixth Circuit affirmed. So the district court said, presumably in light of the Sixth Circuit decision, no. The Sixth Circuit said in light of its own decision, no. En banc is denied, so to the Supreme Court we go. Whether the relevant law bars lawsuits like ours holds consequences not just for Perez, but for great many children with disabilities and their parents. Because our colleagues on the Court of Appeals have disagreed about how best to read the statute, we agreed to take up the question, comparing various decisions, one from the Fifth Circuit, one from the Ninth Circuit, one from the First Circuit, and this one, which is from the Sixth Circuit. So we have a divide of federal authority, which is usually a pretty good reason for the Supreme Court to take the case. All right, we've got a couple different circuits that have spoken to this issue. They're in disagreement with each other. They're not quite sure how to read the IDEA law in light of the ADA and other laws. So there's some confusion. Fortunately, the Supreme Court's here to solve that problem right up. We will solve your confusion because we can bring everyone under one banner. Great. The relevant law provides two salient features. First, the statute sets forth a general rule. Nothing in IDEA shall be construed to restrict the ability of individuals to seek remedies under the Americans with Disabilities Act or other federal laws protecting the rights of children with disabilities. That sounds pretty good for the I should be able to seek relief elsewhere. Second, the statute offers a qualification prohibiting certain suits with this language, except that before filing a civil action under other federal laws, seeking relief that is also available under this subchapter, the procedures under this section shall be exhausted. So you do have relief under other statutes, but there is a provision that says you need to follow these procedures first. In turn, subsection F and G provide affected children and their parents with the right of a due process hearing before a local or state administrative official, followed by an appeal to the state agency. The parties offer very different interpretations of the relevant law. Mr. Perez reads the statute to require a plaintiff to exhaust administrative processes found in the subsection only to the extent he pursues a suit under another federal law for remedies that idea provides. None of this, Perez contends, forecloses his current claim because his ADA complaint seeks only compensatory damages, a remedy that everyone agrees that IDEA cannot supply. So he says the statute, and we go back to the exact language, nothing in the shall be construed to restrict remedies under other laws. So I am not seeking a remedy under IDEA. So I can't be forced to exhaust those remedies. IDEA provides me some remedies, but other remedies, these are not the same remedies. So I can't be forced to go to the IDEA law. Okay. It's his idea. By contrast, Sturgis reads the relevant law as requiring a plaintiff to exhaust subsections F and G before he may pursue suit under federal law if the suit seeks relief for the same underlying harm. So is it based on the harm or is it based on the remedies? On this view, the law bars Perez's suit because it seeks relief from harms flowing from Sturgis' alleged past shortcomings in providing a free and appropriate public education, a harm IDEA exists to address, and then Mr. Perez chose to settle his administrative complaint rather than exhaust his process. So the idea is basically issue preclusion. Issue preclusion is basically the idea, right? Or even claim preclusion, if you like. One of the two. You have a issue with the way that you have had problems in the school district. You sought relief under IDEA. You reached a settlement. And so that settles the issue. That settles the issue. You can't go to another law and seek relief elsewhere. It'd be double dipping. He's like, no, that's not right. These are distinct claims. It's not even claim preclusion. These are distinct claims in his mind because one is forward looking and one's backward looking. So there are different claims. I want relief going forward. I want relief going backwards. Different claims. So no on claim preclusion and issue preclusion also no. So does the settlement under IDEA preclude his ability to go forward because, well, he obviously didn't exhaust all of his administrative remedies because he settled. So does his failure to exhaust his remedies and settle, if you settle, right? You can choose to settle and maybe you settled the whole kit and caboodle. Okay. If both views are plausible, we believe that Mr. Perez's view better comports with the statute's terms. So the Supreme Court's like, no, this is a different kind of relief. It's a different kind of claim. So no. Start with the first clause. It focuses our attention on remedies. A remedy denotes the means of enforcing a right. It may come in the form of, say, money damages, injunctions, or declaratory relief. The statute then proceeds to instruct that nothing in the law shall be construed as restricting or limiting the availability of any of these things under another federal statute. Of course, the relevant law carves out an exception. The second clause bars individuals from seeking relief under other federal laws unless they first exhaust procedures under subsections F and G. But by its terms, this limiting language does not apply to all suits seeking relief that other suits apply. The statute's administrative exhaustion remedy applies only to suits that seek relief that's also available under IDEA. So relief is the touchstone, not the injury. And that condition is simply not met in situations like ours, where a plaintiff brings a suit under another federal law for compensatory damages, which IDEA does not provide. So this again is about the exact words on the page. This is just the exact words on the page. Congress wrote relief. You can't seek relief that IDEA provides except through IDEA. And then once you exhaust that, then maybe another statute. So you can get relief under another statute, but you first have to get the relief under IDEA. But if IDEA never offers the relief at all, which it doesn't in this case, then IDEA is irrelevant because IDEA only creates this hurdle with respect to the relief. Congress wanted this law to be superseding by its language with respect to these kinds of relief. These remedies first, then somewhere else maybe. But if it's a different kind of remedy, idea doesn't speak to it. That does seem to be the language. Admittedly, our interpretation treats remedies as synonymous with relief. But a number of contextual clues persuade us that's exactly how an ordinary reader would understand this particular provision. Not only does the relevant law begin by directing a reader to the subject of remedies, offering a general, and then qualifying role in the subject. And in at least two other places, idea treats remedies and relief as synonyms. And we cannot conceive a persuasive reason why the statute would operate differently only here. So the statute treats the term synonymously. Every provision of law is understood best in its own context. This is a provision of idea. It's understood best in the overall context of idea. Idea itself treats remedies and relief as synonymous. So they're synonymous because there's nothing that says to do something else. The relevant law directs courts in idea cases to grant such relief as the court deems is appropriate. That's statutory instruction. We have said authorize courts to grant as available remedy reimbursement of past expenses. Elsewhere, idea sometimes bars those who reject a school district settlement offer from receiving attorney's fees for later work if the relief finally obtained is not more favorable, which also incidentally is a pretty standard provision in the rules of procedure. So if you reject a settlement and you don't get a better term from the jury, that often precludes things like attorney's fees where there otherwise would be available. It's a way to incentivize people to settle. Nor is idea particularly unusual in treating remedies and relief as synonyms. Other provisions in the U.S. Code do that as well. By way of example, the relevant law provides that the limitations on remedies in this section shall not apply to relief entered by a state court based solely upon claims arising under state law. So you may also have claims under state law, of course, because the state law can always, of course, provide you more protection than federal law allows, unless, of course, the federal law explicitly prohibits it. But yeah, you might have some state level claims too. But the federal government has provided you at least some minimum in this law. Likewise, the relevant law indicates the United States may obtain a remedy under this chapter or any other relief circumstances may require. Influencing our thinking as well as the fact that the second clause in the law refers to claims seeking relief available under the law. To seek is to ask for or request. And often enough, the phrase seeking relief or some variant of it is used in the law to refer to remedies a plaintiff requests. Under the Federal Rules of Civil Procedure, for example, a plaintiff's complaint must include a list of requested remedies or what the law calls a demand for relief sought. Right? That's usually the last section of a lawsuit is what do you want the court to do about it? So, yeah. Many of our opinions as well similarly speak to relief a plaintiff seeks as remedies of request. Faced with all this, Sturgis replies that whatever the merits of our interpretation, precedent forecloses it. Oh, this should be good. Specifically, the school district points to Fry versus Napoleon. But the court in Fry went out of its way to reserve rather than decide the question we now face. So, no. And what the court did say in Fry about the question presented there hardly advances the school district's cause. In Fry, the court held that the relevant law's exhaustion requirement does not apply unless the plaintiff seeks relief for denial of a free and appropriate public education because that's the only relief the relevant law provides. This case provides an analogous but different question. Whether a suit admittedly premised on past denial of free and appropriate education may nonetheless proceed without exhausting idea if the remedy is not one of idea's provisions. Those are different things. If idea provides it, then go to idea first. But if not, well, why are we even talking about idea? because IDEA doesn't provide that relief. In most cases, the question is whether a plaintiff must exhaust administrative remedies under IDEA that we cannot supply what he seeks. And here, as in Fry, we answer in the negative. Yeah. So why would you be required to exhaust administrative remedies if there is no way they can give you what you're asking for? It's futile. It's pointless. So we're not going to make you do something that's pointless. That would be dumb. And we're not that dumb. Failing all else, Sturgis closes with an appeal to congressional purpose. The school district worries that our understanding of the law would frustrate Congress's wish to root claims about educational services to administrative agencies with special expertise in such matters. But it is our job to apply faithfully the law Congress has written. Yeah. And we cannot replace the actual text with speculation. Yeah. Even on its own terms, it is unclear what the school district's argument proves. Either interpretation of the law operates to preclude some unexhausted claims. On our view, for example, a plaintiff who files an ADA action seeking both damages and the sort of equitable relief IDEA provides may find his request for equitable relief barred or deferred if he has yet to exhaust the remedies. It's quite mistaken to assume, too, that any interpretation of the law that does more to advance the statute's putative goal must be the law. Laws are products of compromise, and no law pursues its purpose at all costs. And it isn't exactly difficult to imagine that a rational Congress might have sought to temper a demand for administrative exhaustion when a plaintiff seeks a remedy that IDEA can supply, with a rule excusing exhaustion when it seeks a remedy they cannot provide. So, yeah, look, this is the words on the page, and this is Gorsuch writing, and this is just peak Gorsuch, and I'm here for it. This is peak Gorsuch, and I'm here for it, right? Look, Congress writes laws, they write words. Every law is a result of compromise. No law sits as an island. Congress writes what it writes. We just do the thing that Congress wrote, right? We just do that thing. Unless, of course, some other reason not to, like the Constitution or like a major questions doctrine or something. So we do have things that can sit on top of that, but all else being equal, we just do what Congress wrote. It's like, well, this would frustrate Congress's purpose. And it's like, you don't know what Congress's purpose is. They wrote the law. That's what I know. They wrote the words on the page, and it could be the result of a compromise, and it perfectly makes logical sense. It's like, we want these particular remedies to go through this process, and we want these remedies to not go through that process. That's a rational choice Congress could make. So suck it. I like it. It's peak Gorsuch, and I'm here for it. The parties pose a number of additional questions they would like us to answer, including whether IDEA's exhaustion requirement is susceptible to judge-made futility exception, and whether compensatory damages that Mr. Perez seeks in his ADA suit are in fact available under the statute. But today we have no occasion to answer any of that. In proceedings below, the court held that the relevant law precludes the ADA lawsuit. We clarify that nothing in the provision bars the way. The judgment is reversed and the case is remanded, so ordered. And that is all that they wrote. A very short opinion. 10 pages. Not even that, really, because, yeah. But it's very short opinion. So, yeah, I don't know. He's not answering those questions, right? So, because they're not ripe for the Supreme Court to adjudicate. And the Supreme Court doesn't want to because they're not right. So, do you always have to exhaust the administrative remedies, or what if they're futile? Well, we're not answering those questions right now. And can he actually get these remedies under the ADA? Well, we're not answering those questions either. We're just telling you that the IDEA law doesn't step in the way. So whether or not you have a remedy under the Americans with Disabilities Act, not before the court right now. So go back to square one, I suppose, and figure out whether or not you have a remedy there, which I don't know the answer to. I'm not an expert in ADA law. I don't know. Maybe he doesn't have a remedy, but this law isn't going to stand in the way. But more to the point, regardless of whether it helps Perez himself or not, for his particular facts, it is obviously a big win for parents of children who have special needs in school. And that's a good thing. Because if idea governs, then it governs. If not, then if some other statute governs, do that. And now you don't have to wait around for them to dick around if you have a remedy somewhere else. You can go and get that remedy first, or in addition to idea. They're not mutually excluded. So you can file your ADA lawsuit if you have a remedy there immediately. That's not the same remedy as idea. And that's a good thing. It gives parents who have disabled children additional avenue. And it's also, more of the point for me, a fulfillment of the law, which is always what I care about. It's what Congress wrote. And so, Congress does policy, and that's the policy Congress wants, which is logical. So just go do that. So yeah, I think that's a good thing. So I don't really have anything much more to say about that right now. We might as well keep it under half an hour. If you've enjoyed this stream and learned a little bit something about the laws it relates to people with disabilities in schools, and learned a little bit about how Congress has tailored remedies as it relates to those and various things, please remember to give the video a like. It helps with the engagement and stuff. And please remember to make sure also that you're still subscribed, because I don't know, YouTube doesn't like to keep me subscribed sometimes or something. It's always helpful to remember to check. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.